how to sell a house in a living trust in California. That's our topic today. We'll get started right after this. We often work with sellers who are trustees for a trust in California, and they want to know, one, what their legal obligations and options are, and two, how to sell a house in a trust in California with minimal hassle. It may sound intimidating or confusing in concept, but a house in a living trust sale is really very similar to a normal sale and can provide a lot of benefits to trustees and beneficiaries. Hi, I'm Kim Ward. Welcome back to my channel. Here we talk about probate and trust administration, and particularly about selling homes in an estate. My team and I, we're located in San Diego, California, and we've been helping executors, administrators, and trustees for almost 20 years. In order to feel confident as the successor trustee of your loved one's trust, here are some insights that may help you better understand the entire process. So, what is a trust in California's purpose? Well, most trusts are made because the creator would like to help his or her beneficiaries in specific ways that need to be outlined. So when a living trust in California is created, it specifies how and when the trust's profits and assets, in this case, a house in a living trust, will be distributed to the beneficiaries. And it is up to the trustee to coordinate and manage the trust in alignment with the declaration of the creator, the person that originally drafted the trust in California. Usually a house in a living trust is addressed when the owner has passed away or is no longer able to manage the ownership of it. It's also common for homeowners to put their homes in trusts instead of a will, or maybe have both. What is a revocable living trust and how is it different? If the trust in California is revocable, this basically means that the creator can change the terms at any time. A living trust in California is a trust that was established or created while the original trustee, your loved one, of the trust property, while they're still alive. Many times, if someone creates a revocable trust, they appoint themselves as a trustee during their lifetime. If your loved one had created a revocable trust and done this with their house in a living trust, they can manage the real estate as a trustee, just as they would if the title was still in their own name. They can make repairs, they can put the property in the market, they can negotiate a sale, etc. They can treat the house in a living trust the same. When they pass away, the house remains in the trust in California, and in most cases, the successor trustee, the person that was named in the trust to be responsible for the estate after death, they would then, in most cases, need to know how to sell a house in a trust in California. So now let's talk about the benefits of a trust sale. Trusts are great in that they protect privacy. There is very little privacy when someone dies, and the estate needs to be settled as a probate here in California. But it's important you know that when a house in California is held in the trust of the decedent instead of their individual name, all that is in the public records. So when it comes to regarding the sale of the property, the name of the trust is included. So for instance, I'm Kim Ward. I am a trustee, along with my husband Dave, of the Ward Family Revocable Trust. Selling a property that isn't a trust can be of benefit when family tensions are uneasy, as well because proceeds can go to the beneficiaries in designated amounts, without the conflict based on what is drafted in the trust. While the trustee is still responsible for the details, the beneficiaries will receive what the decedent, your loved one, wrote in their trusts so that their wishes are carried out. It's a win-win for everyone. I recently had an initial consultation with the trustee of her mother's trust. Her name is Jill, and she and her husband met with me to talk about helping her to get the house prepared, marketed, and sold for the trust. And when we met at her mother's home, I was a little concerned about the trust situation. And the reason is that when I looked up the public information and the title information, and when I looked at it, it looked like the house was not in the trust. The house was in Jill's mother's name. So I explained that to Jill and her husband, and they were shocked and they were disappointed that the house didn't appear to be in the trust like her mother had planned. Well, what happened was that when her mother did a refinance 10 years earlier, in order to refinance, you have to pull the house out of the trust and into the name of a human, a person. And after the refinance occurred, and this happens frequently, the house did not get put back into the trust. So all is not lost. I am in the process of helping Jill. She's working with an attorney to get a Heggstad petition put into place. And what that will do is there's a court date that is months from now that the judge will determine that Jill's mother's intention was to have that piece of property, the home, held in the trust, and the judge will put the property back into the trust. And then once that's done, Jill can go forward with my help to prepare, market, and sell her mother's home as she intended to. But the bummer part is that Jill was really disappointed, and it's months and months, probably about 4 months from the time that I shared with her the issue of the house not being in the trust to the time it will get put back in the trust by the courts and we can get the house sold for her. Now, to continue, as I mentioned earlier, one of the most important benefits in creating a family trust in California or a living trust is that your estate's assets can avoid a San Diego probate. Probate means a long legal process that can lock up the estate for years. Avoiding probate also means that the estate can avoid probate fees and court fees that stack up over that period of time. California probate fees, appraisals, and filing fees can end up costing tens of thousands of dollars when all is said and done. And at a minimum, a probate will last 6 months, but usually 1 to 2 years is much more common. So now let's discuss how is a trust sale handled. In general, the process of how to sell a house in a living trust in California will be very similar to that of a traditional sale. The primary difference is that instead of the name of the seller, the name of the trust will be used in the transaction. The trustee will sign documents and provide California Association of Realtors disclosures to the buyer. However, there are a few small special considerations to prepare for. As the successor trustee, as you work your way through how to sell a house in a living trust in California, you're going to need to obtain a copy of the trust. Escrow and title will need to review various pages of the trust to confirm your ability to represent the sale of the house in a trust. Next, you'll need to do a bit of preliminary research for your state. Every state will require that a grantor, that's you as the trustee, signs a deed assigning the property to your new buyer or the grantee. This is something that a knowledgeable real estate professional can guide you through. And the next thing is the trust documents must be passed along to the title company involved in the transaction. After reviewing the trust, the title company will confirm whose signatures are required. Some may also ask for a tax ID number for the trust and a death certificate if the heirs are selling the house in a trust in California. The next thing as the trustee or grantor is that you will sign the deed transferring ownership to the buyer. Once recorded, the sale of the house in a trust in California is confirmed. In most cases, the state law requires having the deed notarized, so be sure to consult with your real estate agent. Here in San Diego, having the deed notarized is part of the process. And when our personal representative clients live outside the San Diego, California area, we can guide you through the process of locating the right type of notary in your area. Then you simply FedEx the notarized document back to the escrow company. As a trustee, you are responsible for managing the assets of a living trust in California and making decisions that are in the best interests of the trust beneficiaries. It's important to keep in mind that the trust may become complicated after the owner has passed away, and it is up to the heirs to determine the best productive course of action. It is not uncommon for beneficiaries to have strong opinions about how to sell a house that is held in a living trust, and it can be challenging to navigate these differing viewpoints. To avoid liability for breach of trust and to make informed decisions, it is recommended to consult with a qualified investment professional and an estate attorney. These professionals can provide valuable guidance and support as you fulfill your responsibilities as a trustee. I hope you found this of value. Please like, comment, and subscribe and hit the bell button, all the things, because then YouTube will share these videos with others in your exact circumstances. Thanks for watching. See you next week.